Everyone, I'm Ken Falk, Legal Director of the ACLU of Indiana, and as you know, late Friday afternoon, the federal court here issued a permanent injunction against the portions of 1337, the law that we had challenged last year. The provisions had never gone into effect. You probably remember we obtained a preliminary injunction in June, immediately prior to the time they were going into effect. The state did not appeal that decision. Instead, we continued to litigate the decision, and on Friday, the court issued a permanent injunction enjoining the provisions of the law that would have prohibited women from obtaining abortions if the abortions were sought for specific reasons, that would have required Planned Parenthood and its employees to inform women of these new unconstitutional provisions, and that would have changed the way that Planned Parenthood had to dispose of the embryonic and fetal tissue after abortions. All of these provisions were struck down by the court. The law now has been voided, never to have gone into effect. At this point, the state has 30 days from the 22nd, on Friday, to decide whether or not to appeal and to file a notice of appeal. We, of course, hope the state does not do that, but we will have to see what the state does. This is just one, as you know, of a number of lawsuits that we have filed with Planned Parenthood to attempt to stop the state of Indiana from burdening women's fundamental rights of privacy and fundamental rights concerning obtaining an abortion. Despite our success in this litigation, the state has proceeded unimpeded over the years to try and pass ever more onerous requirements and burdens. Although I'm an optimistic person, and I would like to say I hope that this will end the state's efforts in this regard, I am not that optimistic, so we'll have to see what future legislative sessions bring. But for now, at least as far as the Southern District of Indiana, the district court here is concerned, this portion of the 1337 litigation is over. And I'll turn it over to the head of Planned Parenthood.
Good morning. My name is Christy Gillespie. I am the president and CEO of Planned Parenthood of Indiana and Kentucky, and we are pleased with the judge's ruling and continue to, from Planned Parenthood's point of view, we will continue to stand up to any or all who attempt to interfere with a patient's ability to access essential services and interfere with their ability to make their medical choices. And so, again, we appreciate the judge's ruling and appreciate the representation from the ACLU of Indiana and the work that they continue to do in representing constitutional rights of patients to have access to important medical care.
Any other questions?
Any questions?
Basically, what message do you think this sends to lawmakers and to women?
Well, the message I think it sends is that the courts will continue to uphold the constitutional rights of women to make important decisions about their health care, and that those decisions are best left between their doctor and themselves, and that politicians and legislators really don't have any place in weighing in on those medical decisions.
Talk about this one.
I'm not upset. I'm not upset by it. But
speaking for Christy and myself, we're not upset if that's all that
No,
is.
we're not upset.
There's no angst over that.
And this presumably means the state will have to pay your legal fees in this case.
Yes.
Is the state the largest donor to the Indiana ACLU?
Yes. I don't think they really view themselves as donor, let's put it that way. We obviously are a membership organization, and we receive donations from lots of persons. And our actual donations undoubtedly eclipse what we take in attorney's fees. But in terms of what government entity pays the most in attorney's fees, it clearly is the state of Indiana.
Do you anticipate lawmakers won't let this go?
I would not be surprised if there's an appeal, and I can't criticize any defendant from wanting to appeal because that is their absolute right. And we'll have to see what happens. This law was a frontal assault on law that has existed firmly in the Supreme Court since 1973. So I would hope that cooler heads would prevail concerning the appeal. But again, I can't criticize a litigant for wanting to have another court take a bite at the apple.
There's several legislators are talking again about a total abortion ban.
Yes.
Next session. I mean, is that obviously? What would you say to that? Since even just these restrictions are gone.
Sure. The law in the United States is crystal clear. In the first, prior to viability, fetal viability, women have an absolute right to obtain an abortion. It cannot be blocked. Restrictions can be imposed, neutral health care restrictions, and that's where some of the laws developed since Roe versus Wade and since Casey. But the bottom line is the state cannot say to a woman, you cannot obtain an abortion. That's exactly what 1337 attempted. If the legislature passes any laws that in essence or explicitly state we believe that you should not be able to obtain an abortion, then number one, there will undoubtedly be litigation, and number two, absent some massive change in the Supreme Court law, that will be quickly struck down. And the Supreme Court's most recent foray into this area, the whole women's health case from the term before last, reaffirmed the continuing validity of Roe, and in fact even strengthened the burden that a state must maintain to justify restrictions, not prohibitions, but restrictions on the right of abortion. So the legislature is free to do what the legislature does. Legislators took an oath, like I did, to uphold the Constitution and laws of the United States. I would hope that they try and figure out what the Constitution says in this regard. It's pretty clear.
Christy, given the administration in Washington, D.C. and the sort of shifting balance on the Indiana or on the U.S. Supreme Court, do you think that emboldens state lawmakers and perhaps Attorney General Curtis Hill in trying to overturn some long established precedents that existed since, as Ken pointed out, 1973?
Well, you know, I can't speak to what the legislature or Attorney General Hill would think. I think I would just reiterate what Ken has said, is that the law handed down from the Supreme Court is very clear that women do have the right to seek an abortion, and any type of legislation or efforts to go against that will be ruled unconstitutional.